Yeah, hi everyone. So I'm just going to go through my Federal Court of Appeal motion record for the proposed intervener on this is on the prorogation debate in Parliament or in at the Federal Court of Appeal, April 22nd, 2025. On the same day, the court did a mootness check on whether they should dismiss the whole thing. The Attorney General came back and said, no, I don't think so. There is still issues before the court, and referred to my my intervener application as a possible issue. So that's pretty positive news. But so this is a proposed intervener application. And the grounds of the motion are that I was in communication with the Prime Minister's office, the Minister of Justice, the Judiciary, the parliamentary committees, and members of Parliament requesting a check on the constitutional imperative of fair and impartial trials to be performed by Parliament immediately prior to the Prime Minister proroguing Parliament, which prevented that debate prior to an election, which removed the ability of Parliament to check the power of the executive, which affects the democratic legitimacy of the election. So pretty heavy involved stuff. But the procedural history, immediate procedural history is on September 9th, 2024. I wrote to all the members of the House of Commons regarding my intention to serve them directly with the enforcement procedure of the Charter, Section 24.1. Due to a failure of the Minister of Justice, David Lametti, to do his duty to protect Canadians' right to a fair and impartial trial in the legal system, I provided evidence and argument for the consideration of the members of Parliament to permit informal conversations and resolution. So that's what was right before the members of Parliament, before Justin Trudeau prorogued Parliament on January 6, 2025. Then it was challenged immediately, and there was question as to whether the court could judge it, and the court came back and said, yes, we can. It is judiciable, whether he in fact exceeded his authority, as alleged by the applicants. The court does acknowledge that all the leaders of the major parties had indicated they would vote non-confidence in the Prime Minister at the earliest opportunity. So that's the situation. And the court proposed a test for the legality of the prorogation. Does prorogation frustrate or prevent Parliament's ability to perform its legislative functions and its supervision of the executive? And I added the judiciary, because judiciary doesn't often make note that Parliament has a role to supervise them. If so, does the Prime Minister's explanation for advising Parliament should be prorogued provide a reasonable justification? In any event, are the consequences sufficiently serious to call for the court's intervention? And basically they said that yes, Parliament does have a role, but the absence the applicants failed to demonstrate that the Prime Minister exceeded any limits established by the written Constitution. So that's what the federal court determined. But here we are at the appeal court, and I seek to provide the court with the evidence that the Prime Minister exceeded the limits established by the written Constitution, and that the Governor-General knew about the constitutional deficiencies and failed to take them into consideration in her acceptance of the Prime Minister's request for prorogation. So then as part of the application, you got to talk a bit about yourself. And basically I just sort of say I'm a member of the public. I share equally with all Canadians that the duties required of the Prime Minister and the Westminster parliamentary system be properly enforced by the courts to restore trust in our democratic institutions so that Canadians may have peace, order, and good government. Right to fair and impartial courts, complying with fundamental justice and compliance with the Charter. So all pretty normal stuff. But the court concluded in the federal court that there was no exceptional circumstances. But my evidence suggests that there was. The evidence in my application as intervener suggests that the prorogation done was to obstruct justice and prevent Parliament from debating on the legality of government conduct, preventing debate on the constitutionality of the federal judiciary and the Prime Minister's ultimate responsibility as First Minister to comply with his duty to protect the public from constitutional breaches by the judiciary, which are clearly exceptional circumstances. So then I note there's a bunch of conflicts of interest here. It must be noted that the Federal Attorney General's office is in conflict of interest and a charter breach, as they have not responded to a properly served enforcement procedure of the charter, requesting accountability for the conduct of the Fed Judiciary to be presented by Parliament or provide argument in defence. Furthermore, there was no response provided to the constitutional question asked on the failure of the Attorney General to respond. I'd make a note that there's a reasonable apprehension of bias that they will continue that obstruction of justice in this hearing. And then I make note that the Canadian Judicial Council labeled my request an abuse of process when I asked for their conduct to be reviewed by Parliament. And then in Supreme Court of BC, this is talking about the judiciary's sort of conflict of interest. I asked the judiciary for a writ of mandamus on the Minister of Justice, and they called it irrelevant and provided no further justification. And then I took it to the BC Court of Appeal, and with zero evidence to support their opinion, dismissed my request for accountability as a conspiracy and dismissed my experience in the legal system, saying it does not reflect reality. So I make an assertion that a reasonable, well-informed person would conclude that the judiciary is unable or unwilling to protect the public over their own interests in having no public oversight of their conduct. Basically, the judiciary is refusing to have their discretion examined by Parliament. And they're claiming that their discretion extends to protecting fraud by a lawyer. So the prorogation was a further attempt to prevent legitimate debate and is, in my opinion, an obstruction of justice and a betrayal of the public trust. So the intent of the submission of the intervener to provide the court and the public record with the evidence presented to Parliament, committees, and to members of Parliament that is relevant to the circumstances and legality of the decision to prorogue Parliament by the former Minister of Justice, the Prime Minister Justin Trudeau, to make an allegation of obstruction of justice and breach of trust by the Prime Minister in preventing the constitutionality of the judiciary to be legitimately checked by Parliament by improperly and illegally proroguing Parliament in order to prevent the proper debate as appropriate in a free and democratic state. Got all the buzzwords here going. The granting of leave to intervene will acknowledge the public interest in having Parliament perform its constitutional role under the doctrine of separation of powers to check the conduct of the executive and the judiciary. So I'm asking the judiciary and the attorney generals to allow this to happen, which is their duty to do, but it's a bit of a problem. But I kind of give a bit of a positive note to it. The granting of leave to intervene will begin the process of rebuilding trust in the judiciary with the acknowledgement of the importance of the protection of the public interest. The evidence is presented is relevant to the pursuit of justice, democratic legitimacy, separation of powers, the rule of law, and is in the public interest. There is zero public interest in permitting fraud and corruption by system insiders in our legal system, and it cannot be justified in a free and democratic state. That's the basic position. They asked for me to justify why I should be here, but the purpose of the court is to determine the truth and balance the rights of the citizen against the state, and the proposed suit suit is a reasonable and effective way to bring the issues before court, as there is no other way to prevent a Prime Minister preventing the examination of judicial discretion by Parliament, preventing a vote of non-confidence for failing to protect the public interest in a justice system, if the Prime Minister can prorogue Parliament to prevent legitimate debate. So just firmly establishing that it was an illegal purpose that the Prime Minister prorogued Parliament. And then they go on about why I should be here and what reasons I should be here for, and whether there's public interest in it and all that kind of stuff. And then it's sort of the public interest. The issue of Parliament debating the constitutionality of the conduct of the judiciary is one that transcends the interests of those most directly affected, myself, as well as the potential impact of the proceedings on the rights of those other persons. Obviously, this affects everyone in Canada. And further evidence to support my application of intervener, I note that I had appealed in the Emergencies Act. My evidence included the unanswered enforcement procedure of the Charter, the constitutional question on the failure of the Attorney General to respond to the request to have Parliament check the powers of the Judiciary, and the application before the BC Supreme Court for a writ of mandamus on David Lametti, and the decision postponed until February 14th, 2022, when the Minister of Justice enforced the Emergencies Act, knowing that his personal integrity and the integrity of the legal system were being questioned. And he made false and misleading statements as to his duties in order to avoid doing them, and they were reported to the Ethics Commissioner, the RCMP, and the Prime Minister's office. At that point in time, they declined to hear that part of the thing, and I'm just sort of warning them it would be wrong to do so again, and I make my case for why it would be wrong in here. The intent is why I'm here is to place the court all the evidence, demonstrate to the court that it was for unlawful purposes that was known to the Prime Minister and to the Governor General, and to make the allegation of obstruction of justice, to assert that the Prime Minister knew or ought to have known that his personal accountability was being requested in the House of Commons for his involvement in the failure of the Minister of Justice to respond to the enforcement procedure of the Charter and the subsequent decision to enforce the Emergencies Act upon Canadians, and the refusal to provide the legal reasons justifying that conduct, which the federal court has declared to have been unreasonable, illegal, and unconstitutional. I assert that the Prime Minister knew or ought to have known that the institutional integrity of the Canadian legal system was being questioned and a request for that legitimacy to be tested in Parliament, and that he had a duty to protect Canadians from constitutional breaches by the Judiciary in accordance with the separation of powers. So just laying it out really firmly, what I'm doing here. And then these are the documents that I rely on, the affidavit and letters to Parliament along with the evidence, Exhibit A and B, and there's my affidavit. It's very simple. Motivation is on a desire to access justice, restore the democratic principles enshrined in Canada's Constitution, enforce ministerial and political responsibility, advocate for legal and political reform to better serve the people of Canada, and create a more trustworthy society for my children. All very noble. So then this is the my letter to all the members of Parliament that I sent on September 9th. Parliament to check the powers of the Executive and the Judiciary. This one is to my local MLA or my local Member of Parliament, Richard Cannings, who has never responded to my communications. I go through a summary of the problem, the NDP confidence agreement, and communications with the BC MLAs, and document my communications with Parliament and the Minister of Justice in the Emergencies Act, make the allegation of misleading statements, and the Charter and the Judiciary's responsibility and failures of the Canadian Judicial Council, and the responses of the Canadian Judicial Council, and my application to the BC Supreme Court for a writ of mandamus on the Minister of Justice, and Parliament's involvement in the matter, because the judge that caused all this problems had already been debated in Parliament and they didn't remove him. Sort of comment on my participation in the Judges Act and failure to comply with the Constitution, Parliament's power under Section 99 of the Constitution, the Judges Act, misconduct. The judge is in a position that a reasonable, fair-minded, and informed observer would consider to be incompatible with the due execution of the judicial office. The biggest problem is that it's the Canadian Judicial Council itself that is causing the problem. Is the conduct alleged so manifestly and profoundly destructive of the concept of impartiality, integrity, and independence of the judicial role that public confidence would be sufficiently undermined to render the judge incapable of executing the judicial office? It's meant to serve the public. And then I quote from Cosgrove on judicial independence, basically just sort of letting the members of Parliament know that they have a right to comment on the judiciary, and the judiciary acknowledges that. People need justice, Richard Wagner, and that it is the Parliament that has the duty. The failure of a referee to provide the legal justification for enforcing the Emergencies Act, Senator Carrigan in the Senate, comparing his conduct with North Korea, and just pushing more that Parliament has a role. And I remind Parliament that the Public Prosecution Service of Canada withdrew their prosecution of me of Section 238 of the income tax, the requirement to file in the public interest. That's a pretty heavy-duty statement right there. It's reminding Parliament that they control the public purse in its disbursements, but the public controls the purse directly. A restoration of the public trust is required. Delay and obfuscation is not helping Canada. Transparency and accountability is required. I have provided some recommendations to consider. It's the Prime Minister and the Minister of Justice responsibility. And all authorities agree that petitioning Parliament for redress of grievances acknowledged as a fundamental principle of the Constitution. It has been uninterruptedly exercised from very early time and has a profound effect on determining the main forms of parliamentary procedure. So just basically saying, yeah, I've got a right to petition Parliament. This is the problem in the judiciary, and Parliament has a role to play, and it is legitimate, so get on with it. But everyone's scared to move forward. But this is the evidence that I presented to Parliament. Media, my website, communications with the Judicial Council, communications with parliamentary committees, communications with members of Parliament, informing them of the problems, communications with the Senate during the Judges Act, communications with the Governor-General prior to the NDP coalition and after, when Minister of Justice was not in compliance with the law, communications with the Prime Minister's office through all material times, November 2020 all the way through, my commission with the Public Order Emergency Commission, and then I communicate with referee, communications with the BC provincial jurisdiction, dealing with the problems there, the Attorney General there, and the Premier David Eby. My application to the Supreme Court regarding habeas corpus, which they turned a letter, my letter to the CRA, communications with the MLAs of BC, and then just other stuff. This is my brief with the in support of the Emergencies Act intervener, which was denied, and officially, this is the evidence that I presented to parliamentarians. This is my first public my public protest regarding an allegation of a failure of the judges to maintain constitutionality. And really, my argument hasn't changed, and the reality hasn't changed. And it's all in this document right here, and it lays it all out. Who is on the hook if a judge screws up? It is the Prime Minister and the Justice Minister. If we are ever going to send a message to the Judiciary that parliamentary supremacy over legislation is meaningful, and if the public at large is going to receive that message as well, there is no better time to use that than at a time when something so offends the common sensibilities of the people. So that's what I started off with. This was the letter from the Canadian Judicial Council. You complain that Justice Shaw accepted the evidence of your former spouse and her lawyer instead of accepting the transcript. They committed fraud. And they allowed a judge to not comply with a court order to provide monthly trust account statements. And then they just said it's judicial discretion. And dismissed. They didn't look even at the decision of Justice Shaw before they wrote this letter. Didn't even look at the decision, because if they'd looked at the decision, they would have known that the judge never made this decision. It's only in the transcript. And they never ordered the transcript and examined the transcript because there's never been a transcript ordered on the file. So I made a complaint regarding the member of the Judicial Council and asked them to follow their procedures, and they didn't. So I followed up again, and they still didn't, just refused to respond. So when the Judges Act was going through Parliament, I submitted my evidence. This is back in 2022, and presented the problem of all that, and included emails to the Prime Minister's office, notice of constitutional questions, ethics commissioner, and presented that to the House of Commons, but it's all full of lawyers in the Justice and Human Rights, and they didn't comment on it at all. So I submitted it to the Parliamentary Committee on Public Safety and National Security, and make an allegation that Minister of Justice is failing in his duties, and communications with the Prime Minister's office, and note that I've so I did that kind of thing to all the committees, Standing Committee on Procedure and House Affairs. This is back in March 6, 2023, and basically just asking them for how they would like me to present this evidence to Parliament. And they don't respond to me. I got sent to jail by the Judiciary, and when I came out, I made a brief on the miscarriage of justice, and made my allegation there, and that was before the Miscarriage of Justice Committee, and no one commented on that. Having a judge or a lawyer check for situations of false imprisonment does not properly check the powers of the judiciary. On a personal note, I shouldn't be incarcerated for telling the truth about my bad experiences in the legal system, requesting accountability and transparency and constitutionality to be rigidly tested and enforced according to the established legal rules. We are supposed constitutionally guaranteed these legal rights. I wouldn't return to a store that didn't honor their guarantees because I have other options. But the legal system is operating a monopoly, and Parliament has a duty to enforce the terms of the guarantee upon the judiciary. It is one of the core responsibilities of the Executive and the House of Commons. Failure to do so constitutionally should result in the dismissal of the Minister of Justice and the Prime Minister. That's laid out pretty. So then I communicated with other members of Parliament regarding a petition for judicial accountability. This was back in 2021. She crossed the floor from the Green Party to the Liberal Party a month after receiving that document. And that parliamentary petition was never presented to Parliament. October 22nd, I wrote to Pierre Poilievre. He never responded either. I wrote to Jagmeet Singh. I informed him of the Governor General's office. And then I noted that you signed the confidence supply agreement. I would suggest the agreement is not in the public interest and should be revoked immediately. So Jagmeet Singh knew exactly what was going on as well. This is my communications with Richard Canning's petition for Parliament to check the constitution of the judiciary, and laid out the argument right there. He never responds. So I communicated with the Shadow Minister of Justice, Rob Moore. He was in the House of Commons Justice and Human Rights as they were debating the Judges Act. He didn't look very happy whatsoever. This is probably part of the problem. Communicated with Michael Cooper, Conservative MLA, and told him. And Anthony Rota, the Speaker of the House, I was suggesting that I serve him, and laid out my argument. And he gets back to me. I have done my very best as a Canadian citizen to communicate at all times with the appropriate authorities following the law and procedures. Nobody is above the law in democracy. We are equal and have a right to face our abusers and see justice done in a fair and impartial tribunal, complying with constitutional and democratic values. These are human rights that are enshrined in our Constitution and represent the values that Canadians share. There is a path forward to restore trust. Canada will be a better place for our efforts. So, he responded right there. Does not fall into my purview. And then a month later, he got into that Nazi guy in Parliament, and I think that was a setup. I think the Prime Minister's office set him up for failure because of this. But then this is in the Senate. During the Judges Act, I communicated with all the senators and Senate Constitutional Affairs Committee and presented the problem, and I offered to appear in Parliament or anything, and provided a brief for Parliament on a suggestion on proposal for judicial reform. And no one ever responded to that. And I try to do my best, Man's capacity for justice makes democracy possible, but man's inclination to injustice makes democracy necessary. Authority, unless justified, is inherently illegitimate, and that burden of proof is on those in authority. If this burden can't be met, the authority in question should be dismantled. And then, so Parliament is in a very unique situation, as there is a member of the public communicating directly with this democratic institution, alleging breaches of the Constitution by the executive and judiciary, and willing to contribute to the restoration of that breach to improve the public trust in our democratic institutions. But the reality is that no one really wants to hear from me, because you would all feel better if I would just go away and let everyone pretend that everything is just fine and continue doing whatever we are doing for years and years. But everything is clearly not fine, and the legal system has been informed. Knowing these facts and ignoring them is a breach of their ethical duty to improve the legal system. But worse than that, lawyers in the public service are actively obstructing justice and refusing to respond to the enforcement procedure of the Charter, improperly protecting lawyers and judges. I am not going away. The remedy for a breach of the Charter is a restoration of that breach. If lawyers had complied with the Charter, you would have in your hands a properly researched and written Judges Act to attempt to restore the public trust. But instead, you see more evidence of what the public experiences, denial and breaches of the public trust from our country's most trusted advisors. The current legal advice of the government is that they are not bound to comply with the Charter, and a refusal to justify their position, a claim that they are above the law. No one ever responds. So back in 2021, I communicated with the Governor General's office and informed her that I had served the Attorney General's office and that David Lametti had refused to respond, obstruction of justice, communication with the Parliamentary Ethics Commissioner, and outlined her Governor General duties. I am suggesting that because the Liberal Party has a minority government, the Governor-General should prorogue Parliament and compel the Minister of Justice to present the Charter complaint to Parliament. Failing to do so is contrary to the Charter and thus unconstitutional. The Governor-General should refuse assent to any law until this matter is resolved. It is in your power to enforce the Constitution. And I quote from Constitutional Law by Peter Hogg, and give his argument. And the second reserved power of the Governor-General is the power to dismiss the Prime Minister. The dismissal of a Prime Minister automatically involves the dismissal of the entire ministry. When does the power of dismissal arise? Could the Governor-General dismiss a ministry because he or she believed its policies to be illegal? I communicate with you with respect for the powers of your office to compel a government to operate within the rule of law and the Constitution. I should not have to have taken this message this far, but I will go further if necessary. I remain bound to the Charter as a citizen of Canada. So, I didn't get a response to that letter either. But I get back to her and ask for a follow-up, but don't get it. But then I communicate with the Prime Minister's office, and they acknowledge receipt and forward it on to David Lametti. I'm saying that he's not in compliance with the Charter, and they respond appropriately. And David Lametti responds, but when he does, actually, I communicate with the Prime Minister's office again, and allege that the Minister of Justice is not doing that, and they forward it on to Marco Mendicino, Minister of Public Safety. Your comments have been carefully reviewed. He's in breach of the Charter. They know it all. They've got all the information. I quote from David Johnson David Johnson, a beautiful book, Trust. He was the 28th Governor General of Canada. Beautifully written book. Highly recommend every Canadian read that. Inspiration for what Canada could be, and how far Justin Trudeau fell from that ideal. But the Prime Minister's office did forward the matter to David Lametti, and David Lametti did end up responding to me. But I did respond to, I communicate with the Prime Minister's office all the time. This is giving him the transcript for the writ of mandamus application, and the government is not in compliance with the law and refuses to respond to a constitutional question regarding that conduct. This type of conduct cannot happen in a democracy, and yet it is happening now under your watch. You are the Prime Minister, and that should mean something. There is a good opportunity here and two choices, the right one and the wrong one. So he was completely informed. Laid it all out there. The Attorney General refusing to respond to the enforcement procedure of our governing document. This is my communication with the after the Court of Appeal. I urge you to resolve this matter for the reasons provided by Lord Dicey. Frequent use of unbridled judicial power contains the seeds for its own destruction because it will erode the perceived legitimacy of the judiciary. It is established law that Parliament alone has the authority to provide the necessary checks and balances on the powers of the judiciary. He absolutely knows what's going on and absolutely refuses to protect the public. And here's another letter letting him know of what's going on. But they don't do anything. But I did submit my evidence regarding the communications with the Prime Minister and the Minister of Justice, and all that information to POAC regarding the Emergencies Act, the enforcement of the Emergencies Act, and it never got presented before the judge. I did get confirmation of its being received on the day after Christmas, actually, Boxing Day. It was very strange. I communicated with Arifa Annie. Please correct me if I am wrong, but my understanding is that the administration of government is not in compliance with the law and the safety of Canadians cannot be guaranteed. Dropped it all on him. I am willing to work with you to restore trust in our democratic institutions. No response. And in BC, I communicate with the Attorney General of BC and make an allegation that the BC Law Society is not complying with its statutory purpose, and Premier David Eby knows about it, and all the problems in BC. Failures of the judges to administer the Provincial Court Judges Act, and all that kind of jazz. They respond. They don't respond to that one, so I send another one, another registered letter. And then, yeah, they just lay it all out there. It's more a repeat of the same, but they get back to me and say everything's fine, no problems here. This is my letter to Premier David Eby, so that he would be informed. I wrote to all the premiers of all the provinces on the same day, every single province and territory, and informed them of the constitutional violation by the federal attorney generals and what the problem was, and some of the legal arguments, and all the history, submitting it to the Emergencies Act, communications with the Prime Minister, the Charter. Never get a response. No response. And then what's this? So, and then when I was incarcerated by the Judiciary, I submitted an application for habeas corpus, and then this is my follow-up, where the Supreme Court denies habeas corpus. Failures in the rule of law. So then I write to my MLA and all the MLAs and lay out the problems more in the BC jurisdiction with failures of procedures in BC, and the judges in BC that have failed to do their duties, and my communications with David Eby, and the lawyers at the Attorney General's are asserting that the judicial is supreme and not subject to oversight by the legislature. The Judiciary is also refusing reasonable legal attempts to provide legitimate checks and balances. Without the protection of the representatives of the legislature, the citizens of Canada are vulnerable to these abuses of power. The legislature is the appropriate forum to address the problem of law societies and the family law as they are creations of the legislature. So just laying out there that there's problems in provincial jurisdictions plus federal jurisdiction, and the legislature has a duty to perform, and no Canadian should be subject to judicial dictatorship supported by the executive in the form of the Attorney General's office. Access to justice is a public service which must be protected from corruption by the legislature. This is the exact moment when the importance of the Legislative Assembly shines to truly protect the public interest. British Columbians and Canadians should not be coerced into trusting a legal system that clearly is dysfunctional for the needs of the public. The restoration of trust in our legal system is of vital importance to the national security of Canada. A citizen of British Columbia and Canada who is being guaranteed rights in our governing constitution. And then all my attachments and no response. And so I wrote to the CRA because I've been under all sorts of legal problems there. And wrote a very honest letter to them. I struggled with depression from the hopelessness of my situation, and I'm sure my partner, later to be mother of my children, at that time suffered too. It was brutal. For at least 4 years I suffered severe PTSD and general dysfunction on many levels. BC Child Support Collection Services attempted to collect from me the child support that I hired a lawyer 2.5 years previously to correct, and who never did. That was my first experience in 2005, being in contempt of court for failing to comply with child support, and I had presented evidence to the judge, who had declared that his income is now down to zero and lack of future prospects, but I cannot urge you strongly enough, sir, to get on with your application to vary that order. I hired a lawyer and he never did. So lawyers caused the problem, and now we're here trying to solve it, and lawyers are unable to solve it. And what is this? This is my letter to the CRA. So the CRA was asking for me to pay a tax debt. But what do you think of the fairness of a justice system that claims a judge can ignore the transcript to protect a lawyer committing fraud? The last that I communicated with someone from the CRA was Matthew Hopkins, who had explained my position as he explained the legal action the government was undertaking for failing to file income tax statements. In court, the judge refused to allow Mr. Hopkins to answer the question that I posed to him. So I did try to get... so anyway, I laid it all out there. That's the CRA. They stopped communicating with me, saving Canada Post, or causing Canada Post all sorts of problems. They lost the revenue. Part of my submissions to Parliament included a contribution to the Standing Committee on the Status of Women. I make a note, abuse is a cycle. It is incorrect factually to assert that it is gender-based and it is perpetuated exclusively on women by men. Under this false representation of the problem is resolved, there will be no progress because abuse perpetuates abuse. The only time I ever experienced a feeling of uncontrolled rage is after being subject to the abuse of the family court system. In my experience, the plaintiff's lawyer failed to comply with a court order to provide monthly trust account statements, and it created a fraudulent court order. I had provided the transcript of the hearing to the court to conclusively prove the lawyer's fraud, but the judge merely called upon the plaintiff, a woman, and requested she commit perjury to protect her lawyer. The Canadian Judicial Council approved of the conduct of the judge, and the BC Law Society approved of the conduct of the lawyer by removing evidence from their file the same way they redacted documents in the court file to hide their obstruction of justice. This is the experience men have in the court system. How do you think men feel? Where does this fit with the best interests of the child? When a woman threatens divorce or separation and goes to a lawyer, as she is advised to do, to protect her rights, how do you think men feel? The courts are a direct threat to everything a man seeks to protect his children, personal security, and finances to provide a stable home. Men are often jailed as a result of interactions with the justice system and are certainly accused of all sorts of things to gain a tactical advantage in a biased courtroom. And I make a note that it's before the court, and yeah, just lay that out there for that parliamentary committee. And then this is the motion record of the proposed intervener in the Emergencies Act debate, which was, I submitted constitutional questions, which was, when was the date of that? I wanted to be part of that, but the court basically felt like I really wasn't that connected to it, and they wanted just to dismiss it. But I had submitted all the evidence about the Minister of Justice in this application, and it was pretty damning, but they didn't want to hear about it. That's the affidavit, and that was back in 2024. And this is the constitutional question about the Minister of Justice failing to respond to the enforcement procedure of the Charter. That never gets answered. And this is the constitutional question that I asked the Minister of Justice. The only court of competent jurisdiction to judge the judges who judge the judges is Parliament. I have currently lost most of my legal rights, except obviously my right to life, but I am in fear of losing that. I am hereby applying to Parliament for the protection of my Charter of rights. Obviously, urgency is of prime importance. Never get a response from that, from the Minister of Justice. This is communications with the PM's office. Why should I feel this way? I should feel safe. It is important to view this situation from my perspective. Never. This is the communication with David Lametti. He basically says that the CJC, the Canadian Judicial Council, is responsible and he has no authority to deal with anything, and a lawyer might also be able to help you in pursuing appropriate administrative remedy. And they have legal referral services, which can refer you to a lawyer who can provide you with an initial consultation for a small fee or at no charge. Very nice of him, eh? But I had communicated with every single lawyer that I could possibly get my hands upon, and they all claimed that they had other things to do, or I will not, what was one? They said, I will not represent you now or ever. So I responded to the Minister of Justice and let him know, you cannot possibly have every confidence in the Judicial Council's capacity to deal effectively and appropriately with all matters that fall within its statutory mandate when the Judicial Council is claiming that judges are above the law, that their word can overrule the official transcript, where they refuse to allow their appeal, but that the Judicial Council was stated by that court, by the federal court, to be abusive in the treatment of a judge. If the court finds the Judicial Council abusive in the treatment of a fellow judge, how can a regular citizen of Canada expect better treatment? So just letting the Minister of Justice know that the roles of the Minister of Justice and of Parliament at the end of the judicial discipline process are critical. It's the Constitution. And the Minister of Justice role at the end of the judicial is nowhere set out. But here's Cosgrove And if the question of removal is to be put before Parliament, it is the Minister of Justice who does so. It is open to the Minister of Justice to put the question to Parliament or to decline to do so. Like all acts of an Attorney General, the Minister's discretion in that regard is constrained by the constitutional obligations to act in good faith, objectively, independently, and with a safeguard the public interest. And there's the Marshall test. So I lay that out to the Minister of Justice, and he never responds. And I quote the United Nations Charter of Human Rights: whereas disregard and contempt for human rights have resulted in barbarous acts which have outraged the conscience of mankind, and the advent of a world in which human beings shall enjoy freedom of speech and belief and freedom from fear and want have been proclaimed as the highest aspiration of the common people, whereas it is essential, if man is not compelled to have recourse as a last resort to rebellion against tyranny and oppression, that human rights should be protected by the rule of law. And this is written to the Minister of Justice prior February 14th, 2021, a year before he invokes the Emergencies Act, on the same day that he invoked the Emergencies Act. Your duty is to be the light and protect the integrity of the Canadian legal system and the rule of law. History will be the final judge. At this time, I have advised numerous government departments of the current problems, and they are waiting for you to do your job. I am available to assist in this manner, but in fairness, like you, I should be paid for doing this job. Canadians would expect nothing less. It is simply abhorrent that the Canadian Judicial Council maintains a position that is in complete contradiction with the guarantees provided by the Charter of Rights. No response. So I reported him to the RCMP National Division, which is tasked with investigating, is to safeguard and investigate significant threats to Canada's political and economic social integrity. Under this mandate, National Division investigates complaints concerning federally elected members of Parliament. And so I make an allegation against the Minister of Justice, and they basically ignore me. And they say, this was all happening right December. This is a really interesting date, January 6, 2021. This was the day that that Trump was outside the U.S. calling for his supporters to go to the Capitol, and he was asking Mike Pence to pull the election boxes and take power. So very interesting time. I was watching that on the news as I was writing this to the RCMP, and then this is an anniversary of the date that Trudeau prorogued Parliament too, 4 years later. So continue. You state that the National Division's mandate is to safeguard and investigate significant threats to Canada's political, economic, and social integrity. I can't think of anything more important to safeguard than our constitutional guarantees, can you? I think it is also a significant threat to Canada's political, economic, and social integrity, don't you? But so what you have here is a coup. The courts are saying that they are not subject to the rule of law, they are not subject to the Charter of Rights, and they are not subject to Parliament. This is a problem that fits with your mandate precisely, to safeguard and investigate significant threats to Canada's political and economic and all that stuff. So they write back, and I write back, and talk about fair and impartial trials, and judicial independence, and all this stuff, and they look at it, and they say you should make a complaint to the Civilian Review Complaints Commission, and so I do, and they call it vexatious, and tell me that I can submit it to the Chief of Police, so I do, and I never get a response. And then, so the police here tried to say, well, you're asking us to investigate judges, you're asking us to investigate, no. So then, so they tried to get out of it, and they've acknowledged that they've received my email for abusing the rule of law, and after reviewing all my information, and they determined that I have not provided substantiated evidence of a criminal offense. But they do advise me I can get a lawyer, and concluded the investigation and not to send them any more evidence. And very nice of them to recommend a lawyer, though. But I communicate back to them, and I ask them, what happens if I have or discover further evidence? Should I destroy it or send it to the media instead? I do not understand why you would respectfully request that I do not forward anything. Please explain what I should do next time I discover corruption in Canada. I suppose there is a conflict of interest issue here. How could I reasonably expect the RCMP to investigate the Minister of Justice? Interestingly enough, the judge who initially disregarded the transcript of the trial in order to protect a lawyer was also the subject of a previous complaint to the Judicial Council, where essentially every police chief across Canada weighed in, and it was discussed in Parliament. Justice Duncan Shaw allowed child pornography to be a charter right under freedom of expression, but somehow also found it not a charter violation in my case to reject the transcript of trial, submitted it as evidence to correct a court order, which eventually post-trial I did get changed, just saying that we are on the same side here, unless of course we aren't. And then they come back and say, forget it. And any future communication sent to the RCMP, unless solicited, concerning this matter will not be reviewed and will be destroyed. And I can complain. And I kind of respond back to him, and I understand this will be our last communication, and although we have a difference of opinions, I remain open to re-establishing connection in the future. I wish to emphasize once again that my complaint is not at all about judges. It's about the Minister of Justice not complying with statutory requirements and protecting lawyers and lawyers that have been presented and promoted to judges from investigation by Parliament as required by statute to protect the Charter of Rights, as well as to integrate the legal institution as required for public confidence. No Canadian will knowingly submit themselves to be tried in such a manner. And that's my communication with the police. This is all in my application for the intervener status in the Emergencies Act, and this is my application at the provincial court, I guess, or at the that's Ethics Commissioner, and they initially said that they won't investigate the Minister of Justice, but they changed their mind after a bit and agreed that we apologize if our response to your previous emails gave you the incorrect impression about the application of the conflict of interest to the Minister of Justice. All ministers are subject to the Act. So they did accept my application, but I think what happened was that it became no longer an ethical complaint because it was an obstruction of justice. And so they don't investigate criminal matters. It's only ethical complaints that they investigate. So that went nowhere. I never got any response back after that with the conflicts. Thank you for sending us your completed request for investigation regarding the statutory duties of the Minister of Justice. Will be reviewed. And then this is my excerpts from the transcript when I asked for a writ of mandamus on the Minister of Justice. And it's the full transcript, so the court's fully engaged, fully involved. I told my complete story before the court at that point in time, and I had 2 hours to present my argument. That's what I got. So I did try to tell my story. I was a child in Kenya in 1974 when Idi Amin was in Uganda. I saw Rhodesia in all its glory before the coming of power of Robert Mugabe. I did my first year of law school in Canberra, in Australia, at the steps of the High Court when Justice Lionel Murphy was being indicted on charges of perverting the course of justice, attempting to influence a court case involving a lawyer. I understand the principles involved here, as we all do. Everyone does, from my children under the age of 10 to every Canadian that I've talked to on the streets. They say my case sounds like what we hear about Russia or China or some third world country. So I tell my story, and the judge that heard that had actually made a complaint about a judge who in a rape trial asked the alleged victim whether why she couldn't keep her knees together, or why she couldn't drop her bottom into the sink in the bathroom where she was alleging that she'd been raped. But this judge who worked for Leaf argued that he should be dismissed on that basis. But in this application, she refused to protect a man alleging corruption, and my evidence was the transcript of trial, and the judge called upon the plaintiff to protect her lawyer. So I actually, she had a decision, was supposed to be due on February 14th, 2022. And she didn't show up to court because that was the day that the Minister of Justice enforced the Emergencies Act. And it would not look good. My right to a fair and impartial trial was not provided prior or since. So, this is my written representations for the Emergencies Act, my argument there, and essentially the court didn't want to hear it and denied my application for intervener. And I provided the relevant evidence and said all the right things through it here, but the judges didn't want to hear about it, so they just removed me. It's very simple. So I submitted it as part of the evidence in the prorogation debate as well, because the findings of the Federal Court of Appeal in this case have serious implications for the public interest, as they fundamentally affect accountability of the executive to Parliament and the people of Canada as a free and democratic state. And I laid it out there. The accountability of the Judiciary to the people of Canada is a fundamental democratic right. The lawful procedure was obstructed by the Minister of Justice, improperly protecting judges from legitimate review by Parliament and failing to protect Canadians from abuses of power. The conduct cannot be defended in a free and democratic state. So, I laid it all out there and made all the arguments, but they didn't want to hear it, so they got rid of it. Did all that. The Constitution Act, Department of Justice Act, defines what his role is. And this is the Judges Act, where a judge may be removed by Parliament, and the conditions that a judge could be removed. And here, removable by Parliament or Governor and Council. Nothing in or done or omitted or done under the authority of any of these sections affect any power, right, or duty of the House of Commons, the Senate, or the Governor and Council in relation to the removal from office of a judge or any other person in relation to whom an inquiry may be conducted under these sections. So basically just asserting the supremacy of Parliament. This is the Emergencies Act and case law and secondary sources. And this is the prorogation application, the memorandum of facts and law. It's a pretty simple one, but it's sort of a summary of everything that we've talked about so far. Written representations. As I stated in my application for intervener in the examination of the circumstances of the enforcement of the Emergencies Act, the evidence suggests that the Prime Minister knew or ought to have known that his Minister of Justice was not conducting himself in good faith and was failing in his duties to protect the public and ensure the administration was in compliance with the law. So I tied the whole thing together, that it's all part of the same practice. The executive is trying to shut down the public and allow the judiciary to have absolute power over us. And the decision by the Prime Minister Justin Trudeau to request that the Governor-General Mary Simon to prorogue Parliament was made to obstruct justice to prevent the legitimate debate regarding the conduct of the judiciary as well as the conduct of the executive in their efforts to prevent that debate from occurring, which would have led to the inevitable fall of government. And the circumstances leading up to the appeal, basically just sort of going over Jody Wilson-Raybould, that the Prime Minister fired her and subsequently just got a Minister of Justice that would do what he wanted him to do. And the whole procedural history, my communication with the Governor-General, the confidence and supply agreement, the Prime Minister's office responding to my communications, forwarding it to David Lametti, forwarding it to the Minister of Public Safety, and submitted my evidence on the writ of mandamus to the Prime Minister's office and to the BC Court of Appeal, and made this comment: judges obviously have a conflict of interest in the judging of their own conduct. It is established law that Parliament alone has the authority to provide the necessary checks and balances on the powers of the judiciary. Your Minister of Justice is refusing to respond to the enforcement procedure, improperly protecting lawyers and judges, obstructing justice instead of protecting the public, which is his legal duty. The Prime Minister is ultimately responsible for the conduct of his cabinet. At this time, my understanding is that the conduct of the executive is in conflict with the Constitution and there has been no defense offered and no communication at all, which can hardly be termed to be in good faith. On the basis of these facts, Canadians must conclude that the executive is in a constitutional crisis affecting the legitimacy of the government. I think that was my last comment. February 2023, I gave up communicating with him after that. I sort of warned them here that the Federal Attorney General requested I not be permitted in the previous application because it would not be in the interest of justice to allow him to use this proceeding to advance his allegations of fraud and corruption, and labeled my allegations regarding the Minister of Justice as spurious, which is false, although they have been provided multiple opportunities to present argument and evidence to support their opinion, but have not done so. So just sort of warning them that they can't do it again, that's not going to work. Make a note that Larry Brock introduced a motion to the House to hold the Minister of Justice in contempt of Parliament for failing to provide the legal reasons for enforcing the Emergencies Act, and that he got permission to prorogue. and that the court acknowledges that all the leaders of the major parties had indicated that they would vote non-confidence in the Prime Minister at the earliest opportunity. So, yeah, this is why I should be allowed to intervene and assist the court as they are directly relevant to the inquiry before the court, the legality of the conduct of the Governor-General and the Prime Minister in their decision to prorogue Parliament. So that's what I'm here for. And I have a standing as of right, as I am a member of the public attempting to access a court of competent jurisdiction for the determination of my rights and freedoms. And that's kind of the findings of the Federal Court of Appeal in this case have serious implications for the public interest as they fundamentally affect accountability of the executive and the judiciary to Parliament and the people of Canada in a free and democratic state. So kind of lay it all out there. This is my last ditch effort here to kind of make the court see that there's a significant problem that they need to deal with. Because last time they just asked me, they just dismissed it all, and now hopefully they get the message that it was illegal. And the conduct of the Governor-General was illegal or problematic. And the Parliament is provided with the constitutional duty to check the powers of the judiciary for good behaviour. According to constitutional conventions, it is the Minister of Justice who would present that matter to Parliament as part of his duty to protect the public and ensure that the administration is in compliance with the law. But the Minister of Justice has refused to respond to all reasonable efforts at communication, and the Prime Minister has been informed of those failures every step of the way, including the importance of providing the legal opinion for the enforcement of the Emergencies Act, which was done on the very day the decision on a writ of mandamus on the Minister of Justice was due, when the judge just simply did not show up. It would be a reasonable matter for any member of Parliament to request debate on the conduct of the judiciary and the failure of the Prime Minister to do his duty to protect the people's right to a fair and impartial trial. It is the rule of law that makes political problem a legal one. Law will be engaged at the point where it is clear that the decision is not just undemocratic but also arbitrary, when it offends not just democracy but also the rule of law. The Attorney Generals should reflect on their code of conduct and remember that the judging of judicial conduct is from the perspective of the public, not the judges. The lawyers' legal ethics state judges, not being free to defend themselves, are entitled to receive the support of the legal profession against unjust criticism and complaint. Whenever there is proper grounds for serious complaint against a judicial officer, it is proper for a lawyer to submit the grievance to the appropriate authorities. My comment is, it is not unjust criticism of a judge to complain that a judge protected a lawyer committing fraud on a court order by rejecting the transcript and preferring the recollection of the plaintiff instead. It is a massive conflict of interest for lawyers to claim otherwise, just because the bias is so clearly in their favor. So then I asked the question of, was the decision of the Governor-General to accept the request of the Prime Minister legal? And it's probably not. But let's not get into that. That's a whole nother thought. And then I just basically want to be involved, leave to intervene, to submit further written and oral submissions, to receive all documents, and to be exempted from costs. And that's what it's all about. And then all the supplementals and everything else. So that's that. But we are at the point now where we'll see what they do. The Attorney General seems to be indicating that they are open to the court not declaring the prorogation debate to be moot, simply because Parliament is back, but the legality of the conduct of the Prime Minister has not been checked. So it appears that the Attorney General is going to not argue too much, but we shall see what happens. And that is the end of all that paper. Oh, what else I got here? Oh, the Minister of Justice is... Oh, here's a dual roll of the... Anyway, lots of stuff in here. All the evidence that the court needs to make their decision. This is a good one here. The Charter is the part of the supreme law of Canada, and any law or government decision inconsistent with it is of no force or effect. Both in the provision of legal advice and in litigation, the Attorney General demonstrates the greatest possible commitment to respecting constitutional rights. In this respect, Attorney General's role can broadly be described as an ambassador of the Charter, but they are in conflict with the Charter. The first principle guides decisions on litigation positions. Where an Attorney General concludes that there is no viable argument in favor of the challenged federal legislation or government action, a Charter violation should be conceded. They have conceded basically by not responding to the enforcement procedure of the Charter. They're saying we have no argument. And ministers are accountable to the Prime Minister. They are appointed by the Governor-General on the advice of the Prime Minister, and the Prime Minister may ask for their resignation at any time. As head of government, the Prime Minister has responsibility for the effective operation of the whole of government and often has to answer in the House for the operation of all government departments. So he is ultimately responsible for the Minister of Justice because he hires them and he fires them. So that is the problem. And then this is all the rest of the stuff. The desk book, the books on judicial independence, all sorts of books that I've... Controlling Corruption by Robert Klitgaard. That's one I put there at the very end, just to put it in there. But anyhow, that's it. So hopefully we will hear more. But I'll leave that with you for now.